Hello and welcome to the latest update for the Solicitors Group TSG Legal TV channel. My name is Martin Leishan and I'm an Authorised High Court Enforcement Officer, Group Director of High Court Enforcement Group and Chairman of the High Court Enforcement Officers Association. As a litigation solicitor, may I ask, what is your main aim? Surely it's to do what is best for your clients. Today I'm going to talk to you about judgment debt. If you have a judgment of £600 or more that was obtained in the county court, how would you like to transfer that to the High Court for enforcement? Now, subject to the judgment debt not being falling foul of the Consumer Credit Act, you can merely scan your judgment, email that judgment to us, and we will make an immediate application to the court for transfer. We will pay the court fee, the disbursement, and we will invoice you at the end of the month. Now, we have 90 enforcement officers in England and Wales, and any one of those enforcement officers will be out enforcing your judgment, and hopefully the next thing you know, you have a cheque on your desk paid in full. Other services that we offer at High Court Enforcement Group, we can process serve for you, we can recover vehicles, we can collect commercial rents. We have a whole raft of services. Please visit our website, www.hcegroup.co.uk. You may not need our services at the moment, but please keep in mind our web address so that when you do need our services, you can always refer back to it.
Hello, my name is Johnathan Payne. I'm going to be talking very briefly today on experts and the things that you need to know, both in relation to experts generally and in relation to expert shopping. Now, one case that you do want to be aware of, as far as experts are concerned, is the case of Edwards Tubb against J.D. Wetherspoons. This was a case which was heard in the Court of Appeal in February of last year, which deals with the issue of expert shopping. Practitioners need to be aware of this case because it deals with conditional orders. When you come to get permission to rely on an expert in your practice, you need to get permission under 35.4 of the CPR. Now, there is a power now when you come to get your permission, if, for instance, you've got a report which you don't like, which you then want to hide, get rid of, not disclose, there is a power, should the other party be aware that you've got that report. For instance, if you have expert A, you don't like that one, you go to expert B in the same discipline. There is a power, following the Edwards Tubb case, to order conditional disclosure. So in other words, if you want to rely on expert B, you have to, as a condition of relying on expert B, give up expert A. Now, that is an important point of practice to be reminding you of, and also for you to be advising your clients of in relation to the conduct of litigation. It's an important principle not only to personal injury cases. Edwards Tubb against J.D. Wetherspoons was in fact a personal injury case, but it is of universal application across the board of litigation, in my view. And some important points come from that case. One is in relation to privilege. An expert report is privileged. This case does not change that fact. The privilege is that of your client, as you know, and not of the doctor, of the engineer, so not of the expert who is preparing the report. Now, that's important to remember. Now, what the Edwards Tubb decision does is essentially this. It gives you the right to get another report and rely on it, but as a condition, so the price for doing that is to offer up the other report. The court can't order you directly to give up that report because it is privileged. And of course, privilege remains the most important thing in litigation. But you do want to bear in mind that you may have to make the decision when the time comes to give up that report and rely on the other one. Now, if in fact that situation does arise and you have to give it up, what will be the effect? Well, I would direct you to the CPR and 35.11. 35.11 of the CPR covers this very situation, and what it says is this: in the circumstances where a report is given up and the other side have got it, then they can use it. Now that's something for you to bear in mind. It's for something for you to think about, and the effect that it will have on the case as a whole and the advice you give to your clients. The other interesting case of last year is the Supreme Court case of Jones and Payne. You want to be aware of that case. That abolishes the immunity of experts giving evidence. It is an important case, and it's a case which you want to be advising and have at the forefront of your mind. For instance, if an expert has given a robust opinion and in a settlement, in a joint statement, for instance, has changed that position, you may want to have in mind the Supreme Court case of Jones and Payne, because that is what happened in that case. Other important things and points of principle which you may wish to bear in mind: when you come to ask the court for permission to rely on expert evidence, it is always best, if possible, to name a discipline of an expert rather than an expert name. There are various other things that you need to be careful of when you are instructing. For instance, given the Edwards-Tubb case, I would urge you to be careful in the instruction of your expert. Be sure that you have faith in that expert, that potentially you know that expert, or you know their CV to make sure they are the appropriate expert for your case. And be very careful what kind of documents you're sending to your expert, because if the expert deals with them, lists them, they will be disclosable. So be careful and think carefully about the instruction of your expert. When you then get your report, you'll want to no doubt ask some questions. We know as practitioners you should do so within 28 days of receipt and only once. And the guidance given to you as practitioners in the White Book is that they should be by way of clarification of the opinion, not by way of cross-examination of your expert or the other side's expert, whereas in reality we know that that may in fact be the case. What is now becoming more prevalent is the use of shadow experts, and those are people who are in the background and they advise the party of how to prepare the case, of how to ask questions of the other side's expert, and that expert doesn't enter the arena such that the report could be ordered to be disclosed. You want to think about that and bear that in mind. You may wish to use that should the funding be available. The other point I would bring to your attention, it's something you want to be careful on. If you do use experts, you want to be careful that they are available for the trial. For instance, as far as availability is concerned, if you instruct one shortly before the trial, you want to make sure they can attend the trial, because if not, you will get in difficulties. So that's a snapshot really in relation to experts, but I would urge you to consider the case of Edwards-Tubb and Jones and Payne. Edwards-Tubb is an important decision, but I would say that, of course, because I was in it. But I would urge you to consider those two authorities. Thank you very much.
On behalf of myself and the Solicitors Group, thank you for listening to the Legal Update. Keep an eye for further updates from TSG Legal TV, and we look forward to seeing you again soon.